Welcome to Learn Law with Saiful. Today we'll discuss an essential stage of civil trial: production and admission of evidence. Let's understand how evidence is brought before the court and how it's accepted legally. Relevant laws. Order XIII and Order XVIII of the Code of Civil Procedure, 1908. The Evidence Act 1872, for rules of admissibility. What is evidence? Evidence includes documents, witness statements, electronic records, and physical objects presented to support or refute claims. Two main types. 1. Oral evidence, statements by witnesses. 2. Documentary evidence, written or recorded materials. Step-by-step process. Step 1. Filing list of documents. Parties must file a list of documents, Order XIII CPC. Copies are given to the other side. Step 2. Production of original documents. During hearing, parties bring originals to court. Step 3. Admission or denial by opponent. Opposing party can admit or deny authenticity. If denied, proof may be required. Step 4. Marking and exhibit numbering. Admitted documents are marked as exhibits. Plaintiff, XP1, P2. Defendant, XD1, D2. Step 5. Witness examination. Witnesses identify and support documents. Cross-examination allowed. Step 6. Objection and ruling. Court decides whether to accept disputed evidence. Important notes. Electronic records must follow Section 65B of the Evidence Act. Court may reject irrelevant or inadmissible evidence. Affidavits can be used instead of direct oral evidence, depending on the case. Presenting proper evidence is critical to proving your case. Missing documents or improper submission can hurt even the strongest claim. Thanks for watching Learn Law with Saiful. Don't forget to like, comment, share and subscribe.